Welcome to Real Estate Syndicator Live. I am your host, Mauricio. When it comes to asset protection, not everybody needs a fancy offshore asset protection trust. But then again, insurance alone is never enough. So in this episode, we're going to walk you through the 6 layers of asset protection, similar to layers of clothing, this week on Real Estate Syndicator Live. Not everybody needs a fancy offshore asset protection trust, right? And not everybody should just rely on insurance, right? So everybody's somewhere in between. And when it comes to asset protection, just as a reminder, I used to do this all the time. I'm a former asset protection attorney, a recovering asset protection attorney. I don't do it anymore. But the way I always think of these was sort of layers. And so I always do the analogy now of the layers of clothing, right? So like today here in SoCal, if it's a nice sunny day, then maybe it's okay for you to go out with a t-shirt and maybe some shorts. But as it gets a little bit colder, you might need a long sleeve shirt, button up. And as it gets colder and colder, you start wearing a sweater. And then if it starts to get really cold and it's raining and it's snowing, you might need a jacket. And then, oh my goodness, if it's a blizzard, then you're putting on that heavy, winter coat for all you East Coasters or people from Chicago, like my wife. Anybody from Chicago here, let me know. But it gets really cold over there. So anyway, depending on your specific situation, it's going to dictate whether you need to put more layers of clothing or less layers of clothing. And it's a similar analogy when it comes to asset protection. Some people, all they have is a W-2 job and they don't own any assets. That's going to be a much different scenario than somebody who has a bunch of rental properties or started a syndication business, or somebody who's now, has 7 figures of net worth, maybe they're a doctor or some other profession that's really high risk. They're going to need much more. And so the idea behind this little presentation is to walk you through the 6 layers. So here are the 6 layers of asset protection. Layer number 1 is actually the free variety. There's actually a free layer of asset protection, so I couldn't think of a better one to start with free. And those typically come into examples like, your homestead exemption, for example. There are some states that actually protect a portion of your equity in your home already. Sometimes it's automatic. Sometimes you actually have to do an application. Sometimes it only protects you if you file for bankruptcy, but each state has different numbers. A lot of the states have very little amounts of protection for your home. So let's say usually it's less than $35,000. I mean, the purpose of these statutes really are to make sure you're not completely thrown on the streets and you get turned into poverty when you're doing these. But then there are other states, like, as you guys know, the states of Florida, that have full homestead exemption. So you're able to protect the entire value of your home, which is a reason why people go to states like Florida for the asset protection piece. Similar with 401k plans, for example. If you got a 401k or a pension, that's typically protected automatically from asset protection creditors. Again, I like to give the example of O.J. Simpson. O.J. Simpson, not only after he owed, I don't know how many, I think he owes over $100 million now, but he ended up going to Florida because, number one, his home in Florida is completely protected from the creditors. And also he's got an NFL pension, and the pensions are completely protected. So there are some examples of products already there or things you may already have that are free. So that's kind of your first layer of protection. Just be aware that on some of these, you have to take some affirmative steps. Layer number 2 is insurance. I as much as I have my issues with the insurance and the insurance industry, insurance is always the first line of defense. You want to have insurance no matter what. That's your first line of defense, and whatever you come up afterwards is really your backstop in the event that insurance isn't enough. And most of the time, insurance isn't enough because it's got so many holes in it. I've done several videos now on insurance, but my issues with insurance is that there's a lot of exclusions in them. So even though you're making your monthly payment, your premium payments, when it comes time to actually collect, that insurance may not be there. It's also a really good product for small claims. If somebody slips and falls and you've got court costs, you've got to defend yourself, that's fine. But when it comes to really catastrophic things, which is really what I really try and pay attention to, like if somebody literally slips and falls in your rental property and, dies or gets severe injuries, or maybe a boiler explodes in your rental property, severely injuring people, or maybe you get into an auto accident. Those are kind of the catastrophic things that I look for, and insurance a lot of times isn't enough. People's premiums aren't very high a lot of times. So people have like $1 million insurance policy, which is great, except if you get into a car accident with 4 people and kill a couple people, or even maybe even worse, they're quadriplegic for the rest of their life. And then the $1 million is not going to be, is not going to last too much, or it's not going to go that far, especially since most of these policies are also, by the way, what I call self-cannibalizing, meaning you're going to spend money on your defense, your attorneys, they're going to rack up $100,000 in fees, and that's going to get deducted. So you may end up with something more like a $900,000 policy. But again, sometimes when you have a catastrophic event, especially if you're a real estate investor, insurance just isn't enough. And so you want to have that next layer of protection, meaning what happens if insurance isn't enough? That was your first layer of defense. What's your next backstop? And we're going to talk about the next backstop in a second. Layer number 3, I'd like to call privacy. Now, privacy isn't necessarily an asset protection tool in the sense that it doesn't actually protect you per se, meaning, just because you've hidden something from public view, or it's hard for people to find your assets, doesn't mean that, they can't go after them. But I don't know if many of you knew, but I used to work for a really well-known plaintiff's attorney, mostly personal injury, up in the Bay Area. Just the guy had the late night commercials, and I worked for him after I graduated from college, before I went to law school. And so I had firsthand experience with this. But the first thing a plaintiff's lawyer generally will do before even considering suing you is they're going to do an asset search on you. They're going to look for all your bank accounts. They're going to do a bank account sweep. They're going to do a brokerage sweep. They're going to do a real estate sweep. They're going to look for assets. And if they can't find anything, plaintiffs' lawyers typically don't like to go after cases where, even if they have a really good case, there's no assurance that they're going to be able to collect. And they typically at that point will just look for the insurance policy and then settle for insurance limits. And the reason for that is that most, if not all, plaintiffs' lawyers work on a contingency fee basis, which, if you guys know, they don't get paid unless you get paid, right? So the last thing a plaintiffs' lawyer wants to do is go spend the next 2 or 3 years of their life pursuing this case, winning the case, maybe even dealing with an appeal and winning the case at the end of the day, only to find out that when they start looking for assets to collect, there's nothing there to collect. They just don't want to do that. And one of the key points that most people are not aware of is that collection and your ability to pay a particular lawsuit is completely separate and irrelevant to the lawsuit. So they can't ask you during the lawsuit, how many assets you have, do you own real estate, how much, what's your bank account? All those questions are really irrelevant to the actual proceeding. It's only until you actually get a judgment. So step 1 is to get a judgment. Once you have a judgment, then step 2 is to collect. And during the collection phase, you're able to bring somebody in, do a deposition, ask them about all their assets, and at that point, try and discover. But up until that time happens, which could be 2 or 3 years, the plaintiff's attorney is not going to be able to, if they can't find anything on a public record, they're not going to be able to ask you or request documents showing that. So it's a really powerful tool to, I don't say hide, but to transfer assets into some form of entity that is not attached to your name, so that when they do an asset search, like a bank sweep, for example, they might find your bank account in your personal name, but the bank account that really has all the money is in a separate entity that doesn't have your name and therefore won't show up on an asset search. So privacy is a really big deal, especially when it's combined with some of these other strategies or layers. The fourth layer, or layer number 4, is going to be the entity structuring, or LLCs. That's the one that probably you guys are most familiar with. Like, once you start acquiring some form of assets in terms of some real estate, you generally want to create an LLC or some other entity, but it's generally LLCs for real estate. And the reason for that is you want to separate the ownership. You want to separate your name from the asset for 2 reasons, really. Number 1, you're trying to protect yourself from the asset, meaning if something were to happen to that real estate, something were to happen to that business, something were to happen to that particular asset, you don't want to be the owner of that, because if you're the owner, you're going to be the one that's legally responsible for whatever happens. So real estate, since everybody here is real estate investor, if somebody, even if it's not really your fault, and somebody just happens to slip and fall on your property, or a guest comes onto your property, to your rental property, they slip and fall and they get hurt, then they're going to sue the owner of the property. And you want to make sure that you are not the owner, that the owner is some sort of an entity, generally a limited liability company. On the flip side, you want to protect your assets from you. You are a walking liability. Every day you get up and you go to work, you go into your car, you go do something, you are a liability producing machine. So we want to make sure that if you get sued, irrespective of your assets, irrespective of your real estate holdings, for example, and the classic example is the car accident. So, or if you run somebody over, or there's a business dispute, you get sued unrelated to your assets, you want to make sure that those assets are protected. So you want to create some kind of an entity structuring, which we've done a lot of videos and episodes on that before. But layer number 4 is going to be entity structuring, or LLCs. And then layer number 5 is going to be your asset protection trust. Probably the gold standard, especially if you go offshore, of asset protection. Now, when I say asset protection trust, we're not talking about your living trust. We're not talking about the estate planning tool, because a living trust is a revocable trust, which means you can change it at any time. You can add beneficiaries, take away beneficiaries, change the terms. Because of that, because it's a revocable trust, which is what a living trust is, it has no asset protection value whatsoever. So that's one of the biggest mistakes. I always hear people say, well, do you have any protection? It's like, well, I have a living trust and I put all my assets in the living trust. Living trust purely is an estate planning tool. It's there to avoid probate, which is a whole different topic. But from an asset protection standpoint, a living trust has no asset protection value. What we're talking about here is an asset protection trust, which is an irrevocable trust, meaning once you set up this trust, transfer the assets in there, you cannot revoke it. You cannot change the terms of the trust. You cannot do any of that, which is what gives it that asset protection. What's the word I'm looking for? That asset protection feature. You can go offshore for some asset protection. You can go onshore. If you're going to go onshore, there are certain asset protection states that are better than others, so to speak. And Nevada is probably the most well-known asset protection state there, primarily because their statute of limitations is so short. You can only challenge a transfer into an asset protection trust in Nevada for a couple years. And so after that, there's no way you can challenge the transfer of your assets in there as a fraudulent transfer, which is one of the ways people get around it. So again, asset protection trust, honestly, if they were handing out asset protection trusts for free, then I would say everybody needs one, or everybody should go get one, because it's a far superior tool than just having LLCs or just having insurance. The challenge, of course, is that they're not cheap to set up, right? A domestic asset protection trust may cost you $10,000 to $15,000, plus you've got to pay a trustee in whatever state you're living in. So maybe that's another couple of grand a year. And then offshore, it can be as high as 30 or 40,000. And so again, it really depends on the size of your estate. If you're just there with a couple of rental properties and your estate is worth a couple $100,000, you're probably not going to get an asset protection trust. But as you grow and grow and grow your portfolio, certainly as a real estate syndicator, you might think about that because of all that exposure that you have. You know, if you've raised millions and millions of dollars, those are all potential exposures from the limited partners. So just something to keep in mind of. You generally look at how dangerous your profession is. Again, the example of the heart surgeon, somebody who's a heart surgeon is going to have a much higher chance of getting sued than, you know, a content creator on YouTube, for example, right? So just depending on what you do for a living, and then also how much money you have to protect, you may want to consider layer number 5, which is the asset protection trust. And then finally, layer number 6 is what we call equity stripping or liens. This is sort of the really advanced kind of stuff, so I won't spend too much time on it. But that's the idea that you actually place liens on your assets. The home is a great example. Let's say you have your home and you have a ton of equity in your home. One of the things you can do is quite simply go get a loan from a bank or a home equity line of credit and remove that, get a loan, remove that equity from your house, put it in a safe place, a bank account over here in some other entity, and the bank will then put a lien on your property, probably a second lien on that. So you've actually effectively removed the equity from your home. And if somebody were going to try and take that away from you, well, you've got your first mortgage in place, and now you have a second mortgage by a particular bank or a particular equity line of credit, a home equity line of credit. And then what we typically do for other asset protection stuff or other assets is we just create our own bank, right? We create our own LLC that we control, that we own, and we then go ahead and make a loan to ourselves. We make a lien on our, sort of a friendly lien on our assets, and that way we're able to strip away the assets. Think of it as a business as well. A lot of times you have a lot of expensive equipment or any assets in a business. Well, you can strip away those assets and put them in a different place and simply lease it back to the business, or maybe you give some kind of a contractual relationship for you to be able to use those assets for the business, therefore removing the ownership of the asset away from that property. Intellectual property is another great thing. Most companies, even if they don't have any physical assets like a medical office or something with expensive equipment, you may have some intellectual property, right? Your customer list, or your contracts, your processes, your systems. So you can remove those from your business where all the danger is, put it in a safe LLC that you own, and simply license that use back to the company, effectively removing the ownership. So those are the 6 layers of asset protection. Quite honestly, depending on where you're at, what really works best is some form of combination of all of these. Again, insurance accompanied with LLC, that's, to me, would be sort of my minimum layer would be an insurance policy along with an LLC. Privacy, you can add that to add some stuff. If you're going to do an equity stripping strategy, that works really well with asset protection trusts, because the trust would then create some sort of a lending company that would then make the loan or the line of credit to your business in exchange for that lien. So the lien holder would be underneath your trust. So just a combination of all of these things. But the most important thing, I think I would say this, and I'll wrap it up with this, is simply that the time to do this is before anything happens, right? There's an old saying from, I think it's a John F. Kennedy quote that says, the time to fix the roof is before, when the sun is shining, right? Before it starts raining. Robert Kiyosaki likes to say, the time to put your seatbelt on is before the accident. And so even though it would be nice to wait until something catastrophic happened to then go out and get insurance on it, or go out and create an LLC and transfer assets, at that point, it's too late, because we have something called fraudulent transfer laws, which means if you transfer something knowing that there's already a claim out there, or you should have known that there's a claim out there, then that transfer can be voided by the judge, reversed, and it goes back to your name and therefore can be collected. So the time to do this is beforehand. But again, not everybody's going to need to do the fancy equity stripping and the lien and the asset protection trust. But if you're a real estate investor, you've got some properties, you're probably in the camp where you need some insurance along with an LLC and maybe a little privacy in there as well. So it's harder for plaintiffs' lawyers to actually find all of the properties that you own. But what I would not do, and I think that's ultimately sort of the point I wanted to make this video in this RESL community, is that I don't think insurance is enough. A lot of people just say, just get an umbrella policy, let's just do that. Yes, you should have insurance, but there's way too many holes in an insurance policy, either holes or just the limits are too low, that it doesn't give you the appropriate protection that you need. You want to add another layer. And again, depending on where you are, it will dictate how many layers you do. So with that, I'm going to open it up to specific questions on the topic of asset protection first. And then I'm assuming we're going to have a little bit of time, and then I'll open it up to any kind of syndication question or what have you. But
a couple things. As we expand our syndication business and invest in more assets in various states, what percentage of a GP ownership would you say, if any, justifies a separate LLC versus putting, say, small ownership of GP and different assets in different states in one LLC? Should they all be in a different LLC if they're in different states, if they're small percentages of ownership? And then also, how does the holding company, does that have any play in this list of security of these LLCs, having a holding company?
Yeah, great question. So specifically for a real estate syndication deal, what I would recommend is always separating the GP part. And when I say GP, what I really mean is manager, right? Remember, GP is a vernacular. We use GPLPs, but we don't use limited partnership. We use LLCs, and they have managers and members, right? So a GP is really the equivalent of the manager. And so that's the company or the GP that makes all the decisions, that has all the liabilities. So I don't want the GP owning anything. Like in an LLC, doesn't have to own anything. It's the manager. So I don't like the manager owning any piece of the the syndication LLC. I just want it to be the manager. I want it to have, asset management fees, acquisition fees, disposition, whatever fees you have would go to that management company. Your equity, which is really from an asset protection standpoint, what you're really trying to protect, should be in a separate entity than the management company. Now, maybe we can discuss whether can you do that in your personal name, or should you have some sort of a holding company as your, let's say, call it Class B interest, which is really what you're trying to protect. And that would depend on the state where the syndication entity is set up, because there are some states that are better than others. So for example, if you give you the extreme that probably nobody's doing here, but if you were going to go buy a project here in California, then I would not want you to own, no matter how small or how big your ownership percentage in that syndication, I would not have you own that in your personal name, because if something were to happen to you, got into a car accident, a business dispute or whatever, the judge most likely will hand over your 1% or 2% or 5%, whatever you own of the syndication LLC, that Class B interest, they're going to hand that over to the creditor. On the other hand, if you happen to have a property in Dallas or Houston or San Antonio, and that LLC is a Texas LLC, well, I know for sure that if you ever got sued for any reason whatsoever, then Texas will not give away your interest to the creditor. They'd be limited to a charging order, which essentially means a lien, and they would get your distributions, but they wouldn't be able to get anything else from there. And so from that perspective, I would have those two different ones. But once you create a holding company, assuming it's structured properly, that holding company doesn't do anything, right? It just sits there holding the asset. In this case, it's holding the Class B interest in the LLC, or maybe if it's got another LLC, it's just owning membership certificate, pieces of paper that it owns. I'm not worried about that piece of paper jumping out and suing you. So it's okay to use the same holding company for each individual syndication deal, because that holding company isn't doing any business. What you don't want to have is have the GP the syndication LLC obviously has to be a different one every time. And the GP, again, it has no ownership. So theoretically, if the GP entity were to get sued, what would happen is your syndication LLC would simply fire it as the manager, right? It would just fire that entity as the GP, and we'd go hire another entity that you guys have. So from a holding company perspective, there's no reason to go crazy and set up a separate holding company for every deal, or have 100 holding companies. Most people have one master holding company if you're just using an LLC. If you have an asset protection trust, and the trust would own the LLC, and the LLC in turn would own, the actual asset, whether that's a property itself or another LLC. Remember, holding companies hold safe assets. So they hold bank accounts, they hold precious metals, artwork, collections, like anything that I'm not worried about it jumping out and suing me. And one of those things is LLC membership units. A holding company owns the LLC membership certificates. It doesn't necessarily own the underlying asset. So generally the asset is owned by an LLC. The LLC is owned by your holding company. And then the question becomes, do you have an asset protection trust on top of that? Sherry says, hi, thanks for doing this. My pleasure. If someone were under lawsuit, can he still carry usual business? Can he still carry the usual business of buying assets? So I think the question is, if I'm in the middle of a lawsuit, can I continue to go buy assets? The answer to that is yes, but you've got to be a little bit careful, because anything that let's assume that the end result of that lawsuit is a judgment, then that judgment will then entitle them to go after whatever it is that you own. And so if you buy an asset, no matter where you put it, you obviously know of a claim. You're in the middle of a lawsuit, so you wouldn't be able to put that into an LLC, or you can, but that would be something they would be able to get or have access to. So once you have a lawsuit, it's already too late, so to speak. So there is merit to the argument that maybe when you're in the middle, if you think it's going to, number one, if it's a major lawsuit and you think you're going to lose, and and your assets are legitimately at risk, then you may want to consider not acquiring any assets until this part is settled, because again, the more assets that are available to you, the more excited plaintiffs' lawyers get. So you want to be a little bit careful, but legally, can you continue to buy assets? Of course. Just realize that you're adding those assets into your portfolio. And if there's a judgment at the end of the road and there is no insurance, or insurance doesn't cover you, and they want to continue going after you, those new assets you recently acquired are going to be fair game for any potential creditor. If you'd like to join us live on these episodes and have a chance to get your specific question answered, you can simply go to realestatesyndicatorlive.com and register to be live on the show. Hope to see you then.